My name is Harry. I'm from London.
Meghan Markle here.
Okay, today is January 13th, 2022. It is 2:18 a.m. I have a lot of things to go over with you today. I don't know if I'll be able to go over all of them. There's this one regarding the Prince Andrew with Virginia Giuffre's judgment. I'm gonna go over it. There's 46 pages. That's gonna be on APTS Sussex. And then I have a whole bunch of other tweets regarding the squad responding to it, which will be on POYTE. So I'm not sure if I'll go over all of them, but I want to review the judgment regarding Virginia Giuffre and Prince Andrew. All right, so this is my back end, 1,630 subscribers. But for some reason, for the past couple of days, my revenue have been going down. So now it's at $434.80. So with that being said, I don't want to focus too much on this. Let's go on Twitter, see what's going on. All right, so there it is. This is the person who tweeted it, and I was able to have it, and I posted it on my community board, this link. All right, full judgment and Virginia versus Prince Andrew. I'll come back to it. Let's see. There's 8 comments in here. Let's see what some of the people are saying here. Okay, excellent. I was looking for that. Thank you. So that's David Allen Green. He usually write blogs and responds to it and like put his commentary on it. And I've shared one of those, one of his blogs. I think it was the review of Virginia Giuffre's agreement between Epstein. I think I've shared one of his blogs with you. Okay, well, let's see. A non-lawyer like me, having quickly scanned the key parts of the ground for rejection, will summarize it as justice must be seen to be done. So go to trial rather than construct spurring grounds why no trial should happen. Trial will determine what is just. Okay. What else? Virginia Giuffre is, of course, pleased that Prince Andrew's motion to dismiss has been denied and that evidence will now be taken concerning her claim against him. Quote, she looks forward to a judicial determination of the merit of those claims. End quote. Contrast and compare. Okay. Long live justice. The further you scroll down. All right, so how long before case heard? Trial will probably schedule for 2023. Ordinarily, the next step will be a scheduling order, which will provide for many months of discovery, then time for summary judgment motions. If this judge also has criminal cases, they'll take priority for trial scheduling. Okay, I enjoy the 2009 agreement is far from model of clear and precise drafting. Okay, it must have meant something to them. That's the laugh. It must have meant something. All right, so let's go on it. I believe there's 46 pages. I only read I think I started reading the first one, the first page, and then I went on to the last one. Well, when I say first page, not that one. All right, this one is just saying who, the docket number, who is involved with this agreement. Okay, Virginia Giuffre, plaintiff against Prince Andrew, Duke of York, in his personal capacity, also known as Andrew Albert Christian Edward. All right, that's the defendant. So I'm not going to go over this. Let's not waste time. And this gives you the list of everything. Okay, let's hope I don't mess up because sometimes my eyes can't really see the texting. Okay, let's see here. Okay, Louis A. Kaplan District Judge. So that's his summary. 46 pages. Let's see. Plaintiff Virginia Robert Giuffre brings this action against defendant Prince Andrew, Duke of York, for battery and intentional inflicting of emotional distress. In short, she's alleged that the late Jeffrey Epstein and others trafficked her to Prince Andrew, who took advantage of the situation by sexually abusing her when she was under the age of 18. Defendant denies Ms. Jeffrey's allegation and attacks her credibility and motives. He asserts, in other words, this is just the way the Judge Kaplan, is seeing the judgment that was brought in front of him, the complaint. So he's explaining his understanding of what the suit is. Okay? So now this is the defendant part based on his understanding of it. Defendant denies Ms. Giuffre's allegation and attacks her credibility and motive. He asserts that she was complicit in Epstein's unlawful activities. But this is a motion to dismiss Ms. Giuffre's complaint as legally insufficient. All right? When I saw this part, all right, as legally insufficient, I went straight to the last page. Well, I think it's the page before the last, all right, to see what his judgment was, because yesterday I was really tired. Okay, not to determine the truth or falsity or charges her complaint. And defendant relies mainly, although not exclusively, on a 2009 agreement between Ms. Giuffre and Epstein that settled a difference lawsuit between Giuffre and Epstein that defendant now argues release him from any liability to Ms. Giuffre. All right, like I said, the judge is explaining his understanding of what was brought in front of him. So now he's saying here, the judge, that the complaint is between the complaint like last week that was brought before him was that Andrew was, who is the defendant, is claiming that he is covered under the 2009 agreement. All right. The fact that defendant has brought the matter before the court on a motion to dismiss the complaint as legally insufficient is of central importance. Okay, so this is what really matters right now, meaning like to dismiss this because there's not enough evidence to show that he did anything wrong, something like that. All right. As it well known to lawyers, but perhaps not known to the lay public, the defendant, by making this motion, place upon the court the unyielding duty to assume. Okay, so the judge is saying like he's bringing this as if he can assume. People cannot go by assuming because in the court they want facts, hard copy facts. Okay, so here because the wording of the agreement between Jeffrey and Virginia were not really concrete. There wasn't like a list of names, the unknown and known potential defendant. None of these were concrete. So now Andrew is telling the court to assume he is part of this agreement. But there was no concrete name. The only concrete name that were in the agreement was Virginia and Epstein. That was it. Everything else was just assumption. Okay, for the purposes of this motion only, all right, for only this part, nothing else. But in other words, the focus of this is what Andrew had brought to the judge, all right, to say that he is part of the 2009 agreement. So this is focusing on that only, meaning this writing is focusing on that. Okay, for the purpose of this motion only, the truth of all the plaintiff allegation and to draw in plaintiff's favor all and references that reasonably may be drawn from those allegations. And consequences, the law prohibits the court from considering at this stage of the proceeding defendant's effort to cast doubt, okay, on the truth of Ms. Giuffre's allegation. I like the way he put it. Wow. Because of the law, things that is in the book, all right, the judge cannot assume things based on hearsay kind of thing. All right. So in other words, everyone has the right to the court. So he's saying here, I cannot cast doubt on anybody's thing when I don't have anything concrete to prove, who's right, who's wrong. So that's what I'm getting from this. Even though his effort would be permissible at a trial, in a similar vein, and for similar reason, it is not open to the court now to decide. All right, because of assumption, hearsay. All right, it's not up to him to decide. Okay, as a matter of fact, just what the parties to the release and the 2009 settlement agreement signed by Miss Giuffre and Jeffrey Epstein actually met. All right, okay, as well appear more fully below, the court's job at this junction is simply to determine whether there are two or more reasonable interpretation of that document. So once they go to court, to trial, so Virginia's lawyer's job is to fully explain what the agreement between Jeffrey and Virginia meant. What was this meant? Because when they say known and unknown, so there's a possibility a list of names could possibly be brought. So I'm telling you, some people are shaking at their boots right now because they don't want to be named, but yet they want to be covered under this agreement. Whoever had any sort of a physical interaction with Virginia, they're probably shaking to the boots right now. Because if Virginia brought this same lawsuit to somebody else who did some, who took advantage of her, all right, they most likely will go based on this court judgment, all right, because the thing is not very well explained who is covered under this particular agreement. Okay, if there are the determination of the right or controlling interpretation must await further proceeding. That's the thing that I get here. Yeah. So if we want to know what this agreement, the 2009 agreement, really mean, in other words, it's not up to that judge to determine that on what was heard in front of him the other day. So in other words, he wants this to go to trial for them to explain that a little bit more. So a lot of people's gonna shake under their boots. They thought getting rid of Epstein was a problem solved. They in fact opened a can of worm, and I've said this before. I guess when I was talking about the agreement, is that Andrew, not only Andrew's gonna out himself, he's also making life difficult to other people who are probably could have been covered under this umbrella of agreement. But if they're gonna come to shove, to list all the names, that's gonna be a big problem. Okay, except as otherwise facts. Okay, now I'm continuing facts. Except as otherwise noted, the facts are drawn from Ms. Giuffre's complaint. It bears repeating that its allegation are deemed true for purposes of this motion, whatever a tier of fact ultimately might determine at trials. Wow. Okay, the Epstein sex trafficking scheme. Plaintiff allegation, meaning Virginia Giuffre, arise principally from a sex trafficking scheme orchestrated by the late sex offender Jeffrey Epstein. All right, the court could literally say that sex offender because he had been found guilty on the eyes of the courts. Okay, and he admitted that he was a sex offender, which was in Florida. Okay, which by now has been publicized widely. Okay, there is a saying that it's been known. According to Ms. Giuffre's complaint, Epstein, quote, sexually abused more than 30 minor girls in the United States and overseas from between about 1999 to 2007, in concert with paid employees and others, notably Ghislaine Maxwell, who recently was convicted. Okay, there it is. All this is playing on Virginia's favor, because all the complaint that she's making and all these people have been convicted. All right, and this district of sex trafficking in connection with the Epstein event. Epstein and others lured vulnerable young girls into a scheme of abuse for Epstein's own sexual gratification and for that of some of his powerful and wealthy friends. Okay, these are the ones that are shaking under their boots right now. The known and unknown people, all right, which Andrew was covered under, but now he's pushing himself to audit all the rest because this agreement was supposed to be sealed, and all of a sudden he's telling the court, "I'm covered under this," but this is something that should have been private. How do you know you were covered on it when something your name is not mentioned on it and it was sealed and it was between Virginia and Epstein? Okay, Epstein relied on Maxwell and others to identify and target vulnerable young girls in numerous settings, including, wow, schools, spas, trailer parks, and street. End quote. Epstein recruiters lured these girls into his orbit with the promise of what appeared to be legitimate masseuse position. Okay. He lured those girls, like Virginia, pretending that they would be working to give massages, but instead he had other attention. So in other words, this is the judge's understanding of what was represented in front of him. Once manipulated into returning to one of Epstein's residences, however, the girls were groomed for abuse by Epstein and others through display of wealth, power, and sexual imagery. Okay, once they got them, he lured them. Then he switched. It's like a what do you call it? Bait and switch kind of thing. Epstein did on them. Okay, and Maxwell, by the way, because she was participated in that. And side note, and by the way, I need to know. Once I know more about it, because I've heard that not Virginia, Maxwell's lawyers are trying to get like the verdict be thrown out because of one of the juries who did not disclose he or she was abused, okay, like sexually abused. So they're trying to throw the verdict away like a mistrial kind of thing. So this is something I'm looking for and for me to share with you. All right, let's continue with this. Once initially sexual abuse had occurred, Epstein and Maxwell further manipulated the victims with a combination of promises, threats, and surveillance. Wow. Okay, the surveillance part, I didn't know. So maybe it was around the time where they stopped sharing what was going on in the court, because there was a period of time when the trial of how do you call this, of Maxwell started. I was getting like a lot of tweets about it, and then once they rest their case, how do you call this, the plaintiff rest their case, which was the government, and then it was the defendant turn, which was Maxwell's attorneys, and then they took maybe 2 days to rest their case. So from that, when it was Maxwell's turn to prove herself, I didn't hear anything. There was nothing that was said about her. So maybe it was this around this time they were talking about the surveillance, or maybe the government was saying that. I don't know. But this is the first time I'm hearing this. Okay. At its height, Epstein's sexual abuse scheme, managed principally by Maxwell, was transcontinental. Using his private jet, Epstein trafficked a dozen of minors for sexual abuse at his New York City mansion, his New Mexico ranch, his private island and the U.S. Virgin Island, his Palm Beach, Florida estate, and elsewhere. Okay, in 2008, he pleaded guilty in Florida to procuring a minor for prostitution. All right, so he was a he was convicted, in other words. So this is why the judge was able to say certain things somewhere here. Anyway, I don't want to waste too much time, but I said something where it was well known that he was, sexual predator, this kind of thing. Okay, defendant relationship with Epstein and Maxwell. Again, according to Ms. Giuffre's complaint, the defendant first met Epstein in 1999 through a former close friend, Ghislaine Maxwell. Over the next several years, the defendant traveled with Epstein and Maxwell on Epstein's private plane and was a guest at Epstein's numerous home, including the private island and the U.S. Virgin Island, Little St. James, and properties in Palm Beach and New York City. Epstein and Maxwell were guests at the defendant's 40th birthday party in 2000, as well as at a birthday party that the defendant threw for Maxwell in Sandringham, United Kingdom, in the same year. Oh, so that's how they were able to get those pictures. Okay, so Virginia was there as well. No, that wasn't Maxwell's trial, not at the hearing for Virginia. Okay, so Virginia was there too. So maybe that's why they didn't bother calling her to testify against Maxwell. Okay, in 2006, 1 month after Florida state prosecutor charges Epstein with procuring a minor for prostitution, the defendant invited Epstein to the 18th birthday party of one of the defendant's daughters. Okay, so Andrew's daughter, as recently as 2000. Oh, so in other words, the judge is letting people know. Okay, in 2006, Florida had prosecuted Epstein and charged him for doing things with minors. So in other words, Andrew knew he was a sex offender. Andrew knew he was a sex offender, but yet he invited him. Andrew invited Epstein to his daughter's birthday. That's what the judge is saying here. Okay? In 2006, 1 month after Florida state prosecutors charged Epstein, okay, with procuring a minor for prostitution. Okay? 1 month after that, the defendant invited Epstein to the 18th birthday party of one of his defendant daughters. So in other words, Andrew knew that Epstein was a pedophile. He knew, but yet he invited him to his daughter's birthday party. Okay, so I see what the judge is saying here. Okay, as recently as 2010, and therefore, after Epstein had done jail time in connection with the 2006 Florida charges and registered as sex offender, okay, all this is letting the defendant, what's his name, Andrew, letting Andrew knew that the court is aware that you knew that Epstein was a sex offender, but yet you still keep contact with him. Okay? So the judge is really good here. He didn't say it, plain blank. He's just letting you know that the court is aware that you knew. Okay, let's start from this sentence again. As recently as 2010, and therefore after Epstein had done jail time in connection with the 2006 Florida charges and registered as a sex offender, the defendant was photographed with Epstein and stayed at Epstein's New York City mansion. That's the picture that was taken in Central Park where Andrew's talking to Epstein. So all this he knew of, but yet he's staying at his place. All right? And then the judge let people know. So all the places that Virginia was taken by Epstein. Okay, they even mentioned here New York City. I forgot. It's somewhere in one of those places where they're saying where all places that Virginia had traveled with Epstein. So I see here. Okay, Epstein recruit plaintiff. Ms. Giuffre's complaint continues. Maxwell recruits Ms. Giuffre into Epstein's sex trafficking activities in 2000 when Ms. Giuffre was 16 years old and employed at the Mar-a-Lago, that's Trump's place, club in Palm Beach, like other minor girls whom Epstein and Maxwell targeted. Plaintiff initially was recruited to provide massages and thereafter to engage in a variety of sexual acts for Epstein. Okay, this is the judge's understanding of all of this. From 2000 through 2002, plaintiff traveled frequently with Epstein, both within the United States and internationally, and on his private plane, in addition to being, quote, on call for Epstein for sexual purposes. So in other words, whenever Epstein needs somebody to do some sexual act, they call her. My goodness. Plaintiff on other occasion was lent out to other powerful men. Oh my goodness. So in other words, whenever Jeffrey needed her for himself, he will call her. And when other people, I guess other client, known and unknown people, needed some sexual favor, they will call her. Oh my goodness. Including the defendant, which is Andrew. Okay? So this is where Virginia is saying they probably took her to New York to be in that mansion where Andrew had laid. I mean, if you think about it, Virginia has a very concrete evidence, because if they show him in New York, in Central Park, talking with Epstein, and then could be around the same time where he was taking advantage of Virginia and Epstein's mansion in New York. All right, so this is why she filed it in New York. So there's some couple things that's taking place here. Okay, defendant alleged sexual abuse. The complaint alleges, and the court, for present purposes, is obliged to accept. Okay, there's another part here that pretty much being on Virginia's side. The court accept Virginia's complaint. Okay, that doesn't mean they find either one guilty or innocent or anything like that. It's just that the court accept to hear, okay, to hear Virginia's complaint, okay, for a trial. That the defendant sexually abused Miss Giuffre when she was under the age of 18 years old. On one occasion, defendant allegedly forced plaintiff to have sex with him against her will at Maxwell's home in London. In other words, if Virginia wants, she could even sue Andrew and the UK. But the UK is kind of hard over there because, his mom is pretty much could make things happen. Okay, Miss Giuffre's complaint includes a reproduction of a now widely publicized photograph at Miss Giuffre's Prince Andrew and Maxwell's home, which plaintiff said was taken prior that event. So that picture of, you see Andrew and Virginia hugging, and then you see Maxwell in the back. So in other words, this was taking place, the picture was took place at Maxwell home before Andrew took advantage of her. And all this was a way to frame these people. All these pictures you're seeing all over is to frame these people. But now the victims are fighting back. Well, only one, which is Virginia. Another occasion, defendant alleged abused Miss Giuffre during a visit to Epstein private island, Little St. James. Okay, Miss Giuffre alleges also that the defendant abused her Epstein mansion on the Upper East Side of Manhattan, which lies within this judicial district. All right, so in other words, in New York, where Andrew took advantage of Virginia, took place in Manhattan, which is part of this jurisdiction of the court. So the judge is letting people know that. During that particular encounter, Maxwell forced plaintiff, a child, and another victim to sit on Prince Andrew's lap as Prince Andrew touches her. During this visit to New York, according to the complaint, the defendant forced Miss Giuffre to engage in sex acts against her will and was aware both of her age and that she was coerced sex trafficking victim. So, in other words, based on the judge's understanding, Andrew knew that Virginia was a sex trafficking victim, but yet he still took the pleasure out of her. Okay? In each of these encounters, plaintiff alleges, okay? Remember, the judge have to be very careful with his word to say alleges, because this is not a trial right now. All right? This is to say whether or not Virginia's complaint can proceed for a trial. So right now, this is Virginia's word against Andrew. And then guess what? Epstein is not alive to talk about it, to say his side of the story. So they got rid of him, and then they wanted things to be over, but yet they needed him to exonerate them, to tell them that he covered under that agreement. Okay, in each of these encounters, plaintiff alleges Epstein, Maxwell, and the defendant compel her to engage in sexual acts by express or implied threats and consequences, plenty fear. So in other words, they threat her to do those acts on Andrew, and if she didn't do it, they were threatening her. Okay, and consequences, plenty fear, death or physical injury to herself or another, among other repercussion if she disobey. Okay, so if she didn't do what they say, they were gonna threat her. They were gonna either harm her or do some sort of physical injury to her. So she had to obey. All right. Ms. Giuffre asserted that the defendant's action caused and continued to cause her significant emotionally and psychological distress and harm. Okay. So that's Virginia saying all the stuff that they threat her, push her against her will to do is still hunting her. All right. And Florida state prosecution and the federal non-prosecution agreement. At this point, it is helpful and appropriate to refer to facts not alleged. Okay, so this is what I was saying here. What Andrew was saying was like a hearsay. There was no concrete evidence to for the judge to dismiss it. You're just hearing hearsay, but you have a physical document in front of you, an agreement between Epstein and Virginia, but your name is nowhere to be found. So, but yet you're saying you cover under that. So the judge cannot go based on nothing that is concrete. Okay, and he has his reputation to uphold too. That's one thing we need to understand. Okay, at this point, it is helpful and appropriate to refer to facts, not alleged, and the complaint in this case, but of which the court takes judicial notice. In July 2006, a Florida state grand jury indicted Epstein in a state court on a single count of felony solicitation of prostitution, the Florida state indictment, as will appear that charge remained pending until mid-2008. As previously noted, defendant's motion in this case relies heavily on the 2009 agreement between Epstein and Ms. Giuffre, which already is before the court as a matter of judicial notice. The 2009 agreement contained the following paragraph. Okay. Let's see here. I'll read some of it, but I'm not going to go too much into it because I've covered the 2009 agreement fully in one video. All right. The court takes judicial notice only to the recent of the facts set forth in this section of this opinion and in the case of document for the existence or content of the document, but not for the truth assertion the document contained. All right, see, resume scheme. All right, let's see. Indictment state Epstein number. Okay, so this is the things that were filed. I guess the docket number, I think. I'm not 100% sure. Okay, we printed in the U.S. Department of Justice Office of Pro Respond Report Investigation into the U.S. Attorney's Office for the Southern District of Florida, resolution of its 2006-2008 federal criminal. Okay, this is new to me. I don't remember reading this. So it's not part of the agreement. So this is trial or whatever Epstein was part of. Okay, let's see here. Federal criminal investigation of Jeffrey Epstein and its interaction with victim during the investigation. Example, November 2020, the OPR report contained a great deal of information about how the NPA came to pass, but the court does not take judicial notice of its statement or consider it in deciding this motion. All right, so this is new to me. Something that was filed through the court of Southern District of New York, of Florida. So I'm not aware of this. Okay, so that's why I continue reading. Okay, this is here. First and second parties further stipulate and agree that this settlement agreement is pursuant to and is in fulfillment of Jeffrey's obligation to Virginia. So the judge here is saying this is what the agreement stated, so he can't change that. So it was, okay, first and second parties, which is Virginia and Epstein, further stipulate and agree the agreement was between the first and second party, that this settlement agreement is pursuant to and is in fulfillment of Jeffrey Epstein obligations to Virginia Roberts Giuffre. Okay, there it is here. So the judge is saying the agreement was between Epstein and Virginia, and this is what I was saying. Okay, this is what I was saying. But for some reason, I don't know, I don't remember if I read this on the agreement or is it something from another document that was filed in Florida. Okay, pursuant to and conformity with the non-prosecution agreement, its addendum and its affirmation between Jeffrey Epstein and the United States Attorney for the Southern District of Florida. Aha. The judge got them here. The judge got, how do you call this? Andrew there. I think this was probably what was, remember, Virginia was suing Epstein in Florida. She was suing Epstein in Florida. So for this not to go to trial, Epstein created that agreement. So now the court of Florida is saying this is the obligation between Virginia Robert and Epstein. Okay? Nobody else. So that's what this is here. Thus, the term of the non-prosecution agreement, the NPA, may shed light on the meaning of the 2009 agreement. The court therefore takes judicial notice of the NPA, its addendum and affirmation. For present purpose, the following term of the NPA are of possible interest here. Epstein agreed to plead guilty. All right, so the judge is repeating what was the agreement based on his understanding. What was the agreement between Jeffrey Epstein and Virginia? Okay, there's here. For present purpose, the following term of the NPA are of possible interest here. Epstein agreed to plead guilty to the Florida state indictment and to a state information charging him with solicitation of minors to engage in prostitution. So that's one point we need to take into consideration here. So he wanted Virginia to take the thing out of court. So he pled guilty for doing that. Okay? So he pled guilty for that. 2, the U.S. Attorney's Office agreed to provide Epstein attorney, quote, with a list, oh my God, of individuals whom it had identified as victims, as defined in 18 U.S.C., all right, and in consultation with and subject to the good faith approval of Epstein counsel, will select an attorney representative for these persons who will be paid for by Epstein lawyers. So in other words, yeah, I knew Virginia didn't get a good attorney. I knew those attorneys who made her sign the agreement were not looking at after her best interest, because Epstein chose those people for them. So there's the court here who's saying that. So Epstein chose people who probably, when you go sign something, there's so much papers, and then you have your attorney explaining, oh, this is what this is what that is, so you don't have to sit back and read everything. They summarize each of those pages for you. So I think this is exactly what happened when Virginia was signing those documents. Those attorneys that Epstein chose for Virginia just, brush the thing off, say, oh, this is what you're signing here, this is what this meant, but wasn't really truthful to her. But if Virginia took the time to read it herself, she will see the thing, those document was not in her best interest. So that's what happened here. But it's not for me to say. I wasn't there. So this is just my humble opinion. And there's the judge here explaining that part here, saying that Epstein was to choose representative for those persons who were the victims. All right, let's see here. And the judge is picking some paragraph that stated that. And I think these were from things that were filed in the court, because I don't remember seeing some of those things here. Okay, the agreement defined the term first parties to mean Virginia. Okay, the first party is Virginia, all right, and her agent, attorneys, predecessors, successors, heirs, administrators, and or assigned. Okay, it defined the term second parties to mean Giuffre. Okay, this is what I got. So that was from the agreement. I remember reading this. So the agreement was identified who is involved in this agreement. So none of this mention how do you call this? Mention Andrew. Okay, let's see here. Successors, heirs, and define terms second parties to mean Jeffrey Epstein and his agent, attorneys, predecessors, successors, heirs, administrators, assigned, and or employees. Okay, who are these employees? We don't know. Okay, for ease of expression, unless otherwise indicated, or the context otherwise require, the balance of this opinion uses the term Miss Giuffre to refer collectively to Miss Giuffre and the other included in the defined term first party. Similarly, it uses the term Epstein to refer collectively to Epstein and the others include in the defined term second parties. All right, so let's see here. They list a whole bunch of unknown things, but what was concrete in terms of first parties and second parties is Virginia and Epstein. Okay, see non-prosecutor agreement. All right, so the judge is saying you could see this. These are all public record. If I want to go look for it, I could go to the court in Florida, Southern District of Florida, and ask for this number. All right, but if people don't put it on social media, I'm not gonna go for it. All right, could contact the identify individual to that representative. So in other words, if we need to know who are all these representatives, we will have to go through that list. Who are these people? Okay, Epstein agreed that if one or more of the individual whom the government had identified as victims elected to sue Epstein under this, okay, Epstein will not contest jurisdiction over him in the Florida federal court, and he will waive his right to contest his liability. Oh my God. So no wonder why they got rid of him. So in other words, the government had Epstein as well, even though he agreed with the agreement with Virginia. Anybody that the government, any victims that the government had listed under this, okay, if I go to Southern District of Florida and to get some names, okay, and it's under this document here. This is the number. If I go to Southern District of Florida and request this document, I will know who all those victims is because this is public record. And if any of these are the names the government have listed who are victims under Epstein's kind of tactic, this kind of thing. So automatically, if they decided to sue Epstein, Epstein have no say on that. This is what I'm getting here. Epstein have no say on that because he already pled guilty to the Southern District of Florida. So this is what the court is saying here. Okay, I'm telling you, all these other people who took advantage of those kids are probably shaking under their boots. And that just reminded me when I was reading some of the comments under some of those tweets, there was one tweet in particular who said, oh, I remember when I was taking this test, something CPA test. Okay, I probably got the wrong abbreviation. And says that if agreement was due to things that was like sexual thing, prostitution, that the law will not take it into consideration. So this just proved that. So I believe that person who tweeted that. Okay, and plus I did took a screenshot of it. Okay, in addition, he will waive his right to contest damages up to an amount as agreed to between the identified individual and Epstein. So this is what the judge is understanding here. So Epstein already waived his right for any of these girls to sue him. If the victim decided to sue Epstein, so Epstein have no say. All he has to do is agree how much he's willing to pay for to pay them. That's all. Okay, so long as the identified individual elected to proceed exclusively under, there's the document, I guess the court filing, okay, 18 USC. Let me write this somewhere so I could look what it is. You know what? I could just do that. 18 USC 225. Let me open a tab and see what this is. And maybe Okay, what is that? A court may entertain and determine such motion without requiring the production of the prisoner at the hearing. An appeal may be taken to the court. Okay, what is U.S. motion federal court? Okay, so this is a federal thing here. Section 2255 is the statutory vehicle that the federal prisoner should use to mount a quote collateral and quote attack on his or her conviction or sentence. In general, a collateral attack is a method used to challenge a federal conviction or sentence in a proceeding other than the proceeding that led to the conviction or sentence. Okay, so that's what that means. All right. To waive any, so in other words, this, he waived that. To waive any other claim for damages, whether pursuant to state, federal, or common law. Epstein waivers, however, will not apply to anyone. I was right. Okay? Epstein waivers, however, will not apply to anyone who had not been identified by the government as a victim. Okay? So if the government did not list some names and some of the things that the Epstein was charged of, so nobody can come and claim anything. Okay? Or having been so identified, did not proceed exclusively under, okay, 18 U.S.C. 2255. That's the thing I just read. Okay, the U.S. Attorney's Office agreed that it will not prosecute Epstein nor, quote, institute any criminal charges against any potential co-conspirators of Epstein, including but not limited to, end quote, for specifically identified person if Epstein pleaded guilty to the Florida charges and otherwise discharged his obligation under the NPA. I'm telling you, they got rid of Epstein, but they needed him. They needed him. If he was alive, he could have come and said, okay, this is what happened, this is and this and this. Guess what? If Epstein is not really dead, he can come out because he already got out of his nonsense that they, because I never seen the body. There's a possibility he's still alive. They just claim he's dead and probably in hiding for the rest of his life now. All right? But he can come out and say anything because if he does, guess what's going to happen? He's going to have to come back to jail and face those charges. All right. The NPA bears signatures dated previously in the late September and in October 2007. Ms. Giuffre's complaint alleged that Epstein pled guilty to the Florida information and presumably the indictment in 2008. Okay. Once I reach 1 hour, I'm going to stop and I'll create another video which will continue with this. And I'm not even near, I'm like, what, 11 page? There's 46 pages. Okay, Ms. Giuffre's Florida suit against Epstein. In May 2009, while Epstein was incarcerated in the Palm Beach County, Florida, as a result of his guilty plea to the Florida state charges, Ms. Giuffre sued Epstein in the United States District Court for the Southern District, Florida. Okay, now she's explaining, the court is explaining how Virginia agreement came about. Okay, I think that's the beginning of it because the government have sued Epstein. He was in jail, so Virginia took that step to sue him now. All right, let's see here. Let me go. Okay, Ms. Giuffre sued Epstein in the United States District Court to the Southern District of Florida. The Florida case under U.S. 18 U.S.C. 225 as an alleged victim of Epstein, alleged federal sex trafficking, sexual exploitation, and child pornography offenses. Her complaint asserts that Epstein and Epstein adult male peers, including royalty, politicians, academicians, in other words, maybe some professors or whatever, businessmen, and or other professionals and personal acquaintances had sexually exploited her. Wow. Okay, Ms. Giuffre and Epstein entered into the 2009 agreement, entitled Settlement Agreement and General Release, pursuant to which Giuffre voluntarily dismisses her action against Epstein in exchange for $500,000. In other words, Virginia dropped her case. So she's no longer suing Epstein anymore in Southern District of Florida. Okay, the defendants argued that Ms. Giuffre's complaint against him are barred by the term of the 2009 agreement. Okay, that's Andrew saying that he's not, Virginia cannot sue him. Okay, the federal criminal case against Epstein. And on July 2nd, 2019, a grand jury in this district indicted Epstein for an alleged sex. Okay, let's see here. Sex trafficking conspiracy and the substantive crime of sex trafficking in violation of 18 U.S. Okay, 1591. So New York charges Epstein under this. Let's go look what this is. Okay, let's remove that F. What this is. Let's see here. Whoever obstructs, attempt to obstruct, or in any way interferes with or prevent the enforcement of this section shall be fined. Okay, so what is that? Sex trafficking. Okay, U.S. 18 U.S. Code 1591, sex trafficking of children or by force. Okay, sex trafficking of children or by force, fraud or coercion. Okay, threat of serious harm to or physical restraint against any person. Okay, so that also reminded me of the thing that this person tweeted. All right, so that's what this thing is. So New York had charges Epstein under this. So in other words, I see what Virginia is doing. Any state who is going after Epstein, each state that charges Epstein, she sue Epstein for it. All right, I see what she's doing. I mean, I guess she learned from her mistake. What happened in Florida, I don't think will ever happen to her again, because they manipulate her to sign that agreement, and then, just for $500,000. So that's what happened here. This is why I think she did that bring up to New York. But guess what? Virginia was trying to get in touch with Prince Andrew, but Prince Andrew was ignoring her. So since he was ignoring her, she filed the suit. That's what I understand from her suit. Okay, and I have that on this channel as well. Okay, he was arrested. Now that's Epstein. On July 8th, 2019, on August 10th, 2019, Epstein was found dead. Oh my goodness, was it that close? Okay, yeah. On August 10, 2019, Epstein was found dead in his cell at the Metropolitan Correctional Center. This is where they thought they got away with the nonsense here. All right, the done deal. He can't talk. He can't do this and that. And this is why he was avoiding her, meaning Andrew. So they got rid of him and thinking problem solved. But now they needed him to say if he covers under that agreement. Okay, in 2009 agreement, the 2009 agreement is the crux of defendant's motion, meaning Andrew. This is what he's trying to go cover under. It contains 6 and a fraction page of substantive text consisting of 9 individual label provisions. These are an agreement to dismiss the Florida case. Okay, let's see here, and 1.5 page previously captioned general release that contain additional covenants beyond the release language. Okay, a payment section 3, confidentiality provision, covenant dealing with maintaining Ms. Giuffre's anonymity. 5, a no contact covenant. 6, a provision related to governing law and enforcement of the agreement. 7, a clause concerning attorney's fees. And 8, a collection of miscellaneous provision. A number of these provisions bear importantly on the resolution of this motion and are discussed in detail below, so there is no need to quote or summarize them in general and great detail here. Suffice is, okay, it's to say by way of introduction that. Okay, this motion raises 2 pivotal issues regarding the 2009 agreement. Whether the 2009 agreement demonstrates that its releasing language in Section 2 unambiguously applies to this defendant, and if so, whether the defendant, who is not a party to no mention in the agreement, is entitled to invoke it. So his name is not even mentioned here, but he wants to be part of it. And 2009 agreement is far from a model of clear and precise drafting, both sides agree that Epstein and Miss Giuffre agree to its language. It must have meant something to them. But Miss Giuffre and the defendant in this case disagree emphatically as to what it means with specific to both issue. Discussion. Dismissal on the basis of the 2009 agreement is not justified on this motion. So in other words, the judge said, I can't dismiss that, how do you call it, Andrew is presented, because he doesn't see, there's not clear evidence in here for him to do that, to dismiss it. In other words, everyone has a right to trial. And I did say that. In the eyes of the law in the U.S., everybody who is being accused of, everyone in the eyes of the law is innocent until proven guilty. So now this is where Andrew needs to prove his innocence. Okay, discussion. Dismissal on the basis of the 2000 agreement is not sufficient in this motion. A legal principle. That's all, due to principality. Okay, 1. Materials properly considered. The defendant moves to dismiss pursuant to Rule 12b6. As noted previously, the court in this posture must accept as true or well-pleaded factual allegation and the complaint and draw, quote, all reasonable inferences that can be drawn from them and the light most favorable to the plaintiff. All right. So in other words, they have to go based on the plaintiff, Virginia. So in other words, Andrew just need to prove he's innocent. So they can just dismiss Virginia's complaint. The court has the right to hear her complaint. That's what the judge is saying here. With limited exception, the motion must be decided solely on the basis of the allegation of the complaint, without regard to any extraneous claim or materials. So, in other words, the court must continue to proceed based on the allegation. So Andrew just needs to prove he's innocent. They can't just dismiss it. Everyone in the U.S. have the right to the court. So that's what I'm saying here. Okay, in 2009 agreement, neither appears in nor is referenced to in the complaint, but the copy before the court consideredly is authentic. In other words, what hard evidence. This is what the court is going about. There's a hard evidence. And remember, I've said also, judges have to take consideration previous things to show respect to other judges. So the things was already a done deal in Florida, so he had to accept it. All right, so he's looking at the hard evidence in front of him. That's my little opinion here. All right, its wording, as distinguished from its legal effect, is undisputed, and the court consequently has taken judicial notice of it. Okay. Moreover, notwithstanding the general rule that an affirmative defense is not considered at this stage of the litigation, such a defense may be raised by a pre-answer motion to dismiss under rule. Okay, there's this. I don't know what this is. Okay, on this rule, if the defense appear on the face of the complaint, and while the defendant argument does not rest. Okay, while the defendant argument does not rest on the face of the complaint, here that is a distinction without indifference in light of the fact that the wording in the 2009 agreement, again, as distinguished from its legal effect, is accepted by both parties according to the court considering defendant argument. So in other words, okay, I see what the judge is saying here. So in other words, Virginia signed that agreement. She understood what was on the agreement. So in other words, if she understood what the agreement was, why will she come here and sue Andrew when his name is not even mentioned in the document? All right. So the judge is taking all those hard evidence, those concrete evidence that is there, and then to go by it, and then to allow the court to hear Virginia's complaint, because those documents that Virginia has, there is nothing that says anything with Prince Andrew in it. So in other words, the judge accepts Virginia's case, complaint, and stuff like that. That's what I'm getting here. Okay. government law. And 2009 agreement provides that it shall be governed by the law of the state of Florida. The parties agree according to the court applies Florida law to the two pivotal questions to bear on the defendant release argument. B. Analysis of the 2009 agreement, whether the defendant is among the purportedly released person. We begin by focusing on the first two pages of the 2009 agreement, which contain Section 1 and 2. Section 1 contains agreement of plaintiff and Jeffrey Epstein to dismiss plaintiff Florida case upon receipt of the monetary payment. Section 2, which occupy 1.5 typewriting page, contain among the things language by which the first party, generally Ms. Giuffre, and some others, release second parties, generally Epstein and others. So I'm going to stop now. I'm exactly an hour. I'm going to continue. I'm nowhere near finished. So for the purpose of this video, let's do a prayer. Prayer for justice. Let's do that. Justice. All right. Okay, how do you pray for justice? All right, let's see here. Grant us, Lord God, a vision of your world as your love will have it. A world where the weak are protected and none go hungry or poor. A world where peace is built with justice and justice is guided by love. Give us the inspiration and courage to build it through Jesus Christ our Lord. Let's look for an image for this. Okay, and then I'm going to continue. Let's do this one. Oh my goodness, it's kind of, okay, responsive prayer for justice. Pray for those who are hungry. Pray harder for those who will not feed them. Pray for those who struggle each week to pay their bills. Pray. Okay, let's not waste of this. Let's do here. Pray for justice right underneath. Pray for justice. Almighty God, all majesty and yours alone. You alone judge the nation. Rise up, O Lord. Bring your justice down. Extend your mighty hand to crush the stronghold of the enemy. Send your Holy Spirit and legion of angels to fight for us. Bring justice, my God. The blood of the martyrs cries out, answer their cry. Your perfect justice measured only by your perfect mercy. All transgressions paid in full on the cross of Christ. Let the truth of Christ crucified ring out, O Lord. Let the glory of the resurrection of the Son pour justice down upon us. Come forth, O Lord, come forth now. In the holiest name of all, Jesus Christ. Amen. All right, so this is it. Please take a moment to subscribe, like, and share. If you want to support this channel, there's a PayPal link in the description. You could donate. For those who have donated, thank you. So now I'm going to go to video 2, which will be a continuation of the document.
Harry, sit down. Just sit. Just sit. Harry, sit down. Just sit. Just sit.
It is a great privilege to be with all of you today.
we ask for forgiveness, and please come back.
As you saw me find the love and happiness that I'd hoped for all my life. You are all in this together, and if I may speak personally, we are all in this together, because asking for help was one of the best decisions that I ever made. You will be continually amazed how life changes for the better.